further hearing in the appeals, W children.
Ms. Davis.
My Lords, I believe I have covered the majority of substantive areas. Maloney Junior and I have endeavoured overnight to put together in written form our thoughts on how a judge at first instance should approach this matter, the guidance that they should be given. And that is the typed list that appears before you.
Thank you very much. Do you want to take us through it now?
Yes. Lord, the first thing I can say, on looking at it again with fresh eyes this morning, it occurs to us that exceptional circumstances and where there is specific justification is somewhat tautologous. And to say it is undesirable and should only be required in exceptional circumstances would be sufficient. The thinking behind the idea that it is undesirable for a child to give evidence again goes back to the points I was making yesterday, that is the current evidence base, that it is likely to be traumatic or damaging, and that although one can say that there are perhaps a percentage of children who are not so traumatised or damaged, the current evidence base is not sufficient to counteract the findings of Pigott, and that it is also extremely difficult for a judge in those circumstances to be able to say, looking at a particular child, well, you are one of those that is likely to be damaged, or you are one of those who is not likely to be damaged. Then the issue of the Article 6 rights, which are obviously important in relation to the alleged abuser in particular. Of course, all parties have Article 6 rights, but it is his Article 6 rights that are the particular concern in this situation. And then, in deciding whether there are exceptional circumstances, a list of all the matters that the judge must bear in mind if those factors apply to that particular case. And one in particular, of course, is the age and maturity of the child. That where a child is approaching 17 or 17 and approaching 18, the view a judge at first instance takes as to the extent of the undesirability and whether or not that is an exceptional circumstance may be very different as the view a judge would take if the child was, say, 12. But it is very difficult to put specific age groups on this, as of course children vary a great deal. And then the other issues, which have been highlighted as important in a variety of cases, and indeed in Pigott, the degree of harm suffered, the support the family has from family and other sources, which is a very important point in care proceedings, as I alluded to yesterday, and the significance of the child's evidence to the case and the strength of the other evidence, which of course is a matter that has arisen in some of the criminal cases that have gone to the European Court of Human Rights, as to whether there is such a test as the sole and decisive evidence test, which is a matter of issue in Horncastle, the case of Horncastle, and the strength of the other evidence. So again, that is something that a court would have to bear in mind as to whether it is simply the word of the child against an adult, or what other evidence there is. And that, of course, also, that consideration is perhaps allied with the last consideration, which is number 11, which is the ability of the alleged abuser to challenge allegations. So that if there is other evidence that is relevant, that can be tested, passage of time since a child made allegations, that is important, bearing in mind the matter that was being dealt with yesterday. And my lords, we've put before the court this morning the case that was mentioned yesterday of Reedy child abuse interviews, which deals with mentions the philosophy, as it were, and the evidence-based understanding of the reasons behind the principles laid down in the memorandum, the Cleveland report and the memorandum. My Lords, it was emailed. I'm so sorry.
Yes,
You have it,
we have got
Oh, you
it.
do?
I mean, it seems to be a classic example of just everything being done
Wrong.
as wrong and as badly as it should have been.
Yes, there were repeat interviews.
Have you got a spare copy?
Pardon?
Have you got a spare copy?
Oh, I'm so sorry, my Lord. Have you got a spare?
There was a chief investigator's
Ah,
arrived this morning.
no, it is. Oh, yes, it's on my desk.
Thank you.
It's on my desk. I'm too. Yeah. Thank you very much.
Yes, a classic example of everything that was done wrong, but it was, in particular, it's at the bottom of page 17 and the beginning of page 18, where the judge, the court,
You've got
Make-
a computer
No,
printout.
oh,
well, we've got somewhere you can track it if
We
you...
can track
internal
it.
page 7? Yes, they come up very
6.
faded
Yeah.
in between the paragraphs. You get these little faded page numbers, and they appear at what is in fact the top of each page.
Yep.
But it's internal page 7 of this.
Which
down-
bit?
Internal page 7 of this printout.
Yes, yes, but which bit
Ah.
you...
Where the court says there are, however, some general observations which I feel I ought to make.
Penultimate paragraph,
The
yeah.
penultimate paragraph, yes.
And this is Lady Justice Butler's loss.
Yes. Yes, my lord.
Yes.
My lord, I've lost my crib sheet. Excuse me one moment, my lord. I seem to have put my proposed guidance in amongst read. Ah, here it is. My lords, of course, on that, it can no doubt be argued that, of course, the younger the child, the more those principles apply. But it is perhaps a matter of art rather than a matter of science, at what point it is possible to say that it is no longer the case that the more you question a child, the more it's likely to come up with the answers that you want to hear, and the less reliable the evidence is likely to be.
Just as a matter of interest, and
Yes.
it may be that you can't give the answer, and certainly my experience is very stale, and things may have changed, but in criminal cases, are courts, juries in particular, given this sort of information?
No.
I know that's my, and
not.
yet that is exactly the situation where the child is being questioned, where it's rather paradoxical that in the situation where the child isn't being questioned,
Yes.
all this information is
Yes.
behind the reasoning.
Yes, and of course, one can imagine that in the criminal courts that a 6 or 7 year old child with a grown man, and it doesn't have to be scary. It doesn't have to be a big man in a wig and gown. It doesn't have to be in a courtroom, but simply saying with firmness, "Well, this is what really happened, isn't it?" And repeating it several times may well elicit the response, "Yes," because that is the way sometimes children can be in that situation.
But it happens over a video link, of course.
It does,
Yes.
but there is a huge lack of cross-fertilisation of understanding and ideas between the criminal jurisdiction and the care jurisdiction, and in this area as well as in many others, my Lord, which presumably is a matter of concern to those in the family field and concern for different reasons to those in the criminal field. But Yes.
Is there a criminal specialist or some judge who might even have some influence in the criminal jurisdiction going to be on this Family Justice Council working party, chaired by Lord Justice Thorpe? Who? Do we know?
No, we don't. We only know that they are going to ask
Might have been a
people,
good idea to
but it
have a
might be good
senior
idea to
presiding
say.
judge or something.
Yes, yes. Because there are those of us who see both jurisdictions on occasions. There are lines of questioning pursued in criminal proceedings that are perfectly legitimate in criminal proceedings that would seem quite bizarre to pursue in family proceedings, because their understanding of how children work and what make children tick and how children talk about these things is very different. So to have both, I would agree on the Family Justice Council, to have both disciplines would seem to me to be very important. Yes.
But with the object of educating the criminal justice system rather than the object of educating the family justice system.
Yes. I'm sure the criminal justice people would see it the other way around, but
Exactly.
There might be some advantage to both.
yes, indeed. Passage of time since a child made allegations, again, is something that we would say is probably very important with small children, and possibly by the time they're getting towards adulthood becomes less important. But children may well have, again, this is something that needs an evidence base, a different perception of the importance of trying to give an answer that an adult wants to hear, as opposed to saying, well, it's so long ago I don't remember. Again, these are difficult concepts. Likelihood of any further delay, of course, delay being inimical to children. Likelihood of children having to give evidence in other proceedings, a matter that's already been raised in many cases. Given the evidence base that it's likely to be traumatic and damaging, to have to repeat that experience. Evidence of harm to child from giving evidence, including expert evidence if thought appropriate, that at the point at which a judge's the first instance is concerned that this may well be an exceptional circumstance, and is considering whether or not there is any justification for the child giving evidence in the proceedings, the judge of first instance, perforce, then has to make a decision on all these issues on evidence of harm. And that is a very difficult one, and it's a very difficult decision for a judge, but it is one that would have to be tackled. And it may well be that in addition to the thoughts of the parents, the guardian, and the local authority, and particularly if there are already treating psychologists and psychiatrists involved, or indeed an independent expert, it may be appropriate to seek their advice on this matter. And the child's wishes and feelings, of course.
You need to switch your thing back on.
Oh, I'm sorry, I keep leaning on the button. Yes, and of course the child's wishes and feelings, views of the others, and the ability of the alleged abuser to challenge allegations, which I've already referred to in relation to number 4.
I mean, just going back to the opening words of this paper, the starting point is that it's undesirable. I mean, I just wonder about that. That seems to beg every question. I mean, the starting point is that it's likely to be damaging for a child to give evidence. Is that I mean, that's why it's likely to be damaging. If you say it's undesirable, then you've answered the...
Yes.
You said that it is undesirable,
Yes.
end of story.
Yes.
It
So,
may not be. It may be highly desirable because that's where the balance ultimately falls.
So to have a presumption on the outcome, a presumption on the underlying reasons, which is that the starting point is that it is likely to be damaging and traumatic.
For a child to give evidence in fantasy.
Yes. My Lord, yes.
And which of the next words are you suggesting be deleted? It should only be required where there is specific justification. Well, I think I might accept that. But I mean, exceptional circumstances, we've all been round this course so often.
Yes.
In other...
Yes. Yes, my Lord, giving it thought, I would propose the specific justification rather than exceptional circumstances.
Well, I'm sure you'll be right to do so.
Yeah. because exceptional circumstances, it's, in some respects, nothing is really exceptional in these cases. The specific justification is there needs to be a very good and particular reason as to why the general rule is not being followed in a particular case, and specific justification, my Lord, I would say, would seem to cover that.
I'm not sure, again, one is right to talk about the general rule, because that
Right.
starts the whole exercise with an assumption that
Yes.
it's out, unless very rarely it's in. And
Yes.
the accepted mantra is that it's permissible to say that that is the result of applying the test, but that shouldn't be part of the test. And one sees why.
No.
People feel that it's prejudged, the answer.
Yes, my Lord, and referring back to a matter that I raised yesterday, that I think it was in the case of LM, that it was said, well, it's not a presumption, it's a guideline.
I think it was said it was not a principle. It's a
Yes,
guideline,
it's
actually,
a
but
guide,
it probably
no.
means the same.
Yes. It is a guideline. It is the current view that a child to give evidence is likely to be traumatic and damaging to the child.
So in the second short paragraph, you strike out the words,
Exceptional circumstances.
yeah, whether, you put in whether there is specific justification. In deciding the third paragraph, whether there is specific justification.
Yes. And of course, the last two paragraphs are, well, the first of the last two paragraphs is practical, of course, which presents a difficulty in the current arrangements that are made, because, of course, at the moment, the only way in a combined court centre where a child can give evidence by live link is to make arrangements with the criminal courts to effectively borrow their equipment unless they have it already, and that is simply not possible in some of the smaller courts. And then the cautionary approach that the judge at first instance has to take where the evidence has not been tested by cross-examination. But of course, my Lord, I dealt at some length yesterday with the issue of why testing at cross-examination where there's been an ABE interview is not necessarily in any event the best way to get the best evidence from a child. My lady,
I'm sorry, on the last line, I mean, would you quibble with, in those circumstances, necessarily attach lesser weight to the child's evidence?
my Lord, no.
The alternative point of view to that is that if we accept what is said, which comes straight out of Cleveland, as to the factors tending to support the reliability of a child's evidence. In other words, not putting leading questions. Questioning the child much closer to the event than many months later,
Yes.
or whatever. All of those sorts of things.
Yes.
It could be said that more weight should be attached to that evidence than would be attached to evidence, especially evidence in chief, given much later. And the problem with cross-examination is that it does put leading questions
It does indeed.
to a child in circumstances where the child may be very tempted to say yes, even though that is not necessarily correct.
Yeah.
Of course, it is going to vary an awful lot with the age and maturity of the child. There's no doubt about that.
Yes.
But those are reasons for saying the fact that those questions in a leading form have not been put to the child now doesn't necessarily affect the reliability of the child's evidence.
No.
I think that's what you're trying to argue, isn't
Yes.
it? I'm not saying I agree with you, but I'm just...
No. That the reliability of a child's evidence really falls to be considered in different ways other than via cross-examination. In that one would be considering the circumstances in which the allegation was made, the possibilities for the child having misunderstood, having been put up to it, the degree of vagueness in the answers it gives, the quality of the questioning in the ABE interview, which is not always of the best, and sometimes experts are asked to look at that. The reasons a child may or may not have for making allegations that are not true. And also, of course, any subsequent disclosures that the child may have made spontaneously, which does happen in a number of proceedings, that are usually recorded by professionals in note form and then fall to be considered. So there is a lot of consideration of the credibility or otherwise of what the child is saying, aside from cross-examining the child and saying to the child, well, this isn't true, is it? Or however the child is cross-examined. So it doesn't become, simply because a child is not cross-examined, it doesn't become the case, well, you've got the interview, it says this happened, and you have to believe the child, and that's it. It doesn't end the case simply because a child isn't cross-examined. There's still a great deal to be considered and assessed by a judge at first instance. So in attaching appropriate weight, I suppose what I'm trying to say is one wouldn't attach less weight to a child's evidence just because the child hasn't been cross-examined. But there are many, many reasons why one might attach less weight to a child's evidence.
Well, I'm sorry. I mean, I recognise that cross-examination, may take the child astray. One would hope a family division judge would be able to see through that, and not just because the child maybe is changed in the face of cross-examination doesn't necessarily mean that the cross-examined answers are necessarily any more or as reliable as the other ones. But it's just that completely untested. I come from a tradition where I think if you said, frankly, it doesn't matter that this hasn't been cross-examined to, it carries exactly the same weight as if it had, I find that difficult.
My Lord, I think what I was going on to say is that this would, it's not right to say baldly that because it's untested doesn't matter. That is something, again, that varies a great deal with a child's age. That it might well be, it's easy to say on the peripheries, that it's much easier to say in relation to a child of 4, for example, that there are huge dangers in cross-examination, and testing by cross-examination is really not appropriate. It would be a very different consideration, perhaps, with a child of 15, or certainly 16 or 17, and at 17 one might well expect the child to be giving evidence in any event. It becomes much more a matter of a judgment for the individual judge at first instance when you're dealing with 11, 12-year-olds.
Yeah, well, I think we have discussed this point at some length now.
Yes. So the judge would have to bear in mind that, say, a 12-year-old's evidence hasn't been tested, but how appropriate would cross-examination of a 12-year-old be in any event? And is this a particularly bright 12-year-old? Or, but of course there are other matters other than intelligence. So
I wonder whether there isn't a more fundamental conception of justice at the root of the principle that if an accused hasn't had the chance to address his case directly to the accuser, then you would give less weight to the accuser's statements. Because I think one is, as a result of this exercise, drawing certain conclusions about the rights of the accused, if I can use that word, and it is an elementary expectation of justice that you will have the chance not merely to have your say, but actually to have your point of view put even if you don't put it directly to the other side. I don't say that it's in sort of face-to-face and frowning, brow-to-brow Shakespearean fashion, but it's
Yes.
in some form.
Yes.
So I just wonder whether, irrespective of whether you can say, well, the psychologists tell us that children
Yes.
are very reliable when they speak in this natural, immediate way, which I fully understand, whether there isn't something more fundamental, actually, which
Yes.
precludes us giving it quite the same force.
Yes. Yes. Well, Lord, I entirely see the force of that argument, that it's where the person accused has an explanation for events and is then in a situation where he cannot and nobody else is allowed to say to the child, well, he says, well, this is what happened, what have you got to say about it? Yes, that is very unsatisfactory. Of course, the original idea of Pigott was that the child would be you would do the ABE interview, and then within a very short period of time, the defendant's case would then be put to the child in a second short interview, not going to court and the rest of it, but the defendant having said what his response was.
What have you got to say? And
yes.
Well, there's no reason in principle why that shouldn't happen in family proceedings.
No. The reasons why it doesn't happen and can't happen, of course, are entirely practical, which are that it can take many months to extract the evidence from the police, and it can take equally as long, if not longer, to extract a version of events from the person against whom the allegation.
Why does it take so long to extract the video from the police?
It doesn't take. It's not necessarily the video. If the police are still undertaking investigations, they're loath to give all police disclosure.
Well, that I understand, but
Yes, and if they're not in,
my experience was you got the video straight away.
well, very often you get the video quite
Yeah.
soon. Yes, if the police undertake a video. Of course, the problem then arises in all those cases where the police, for whatever reason,
And sometimes there are very good reasons for not
Yeah.
doing that.
But in practical terms, it can take a series of directions and a series of increasingly vehement orders to extract disclosure from the police, up to and including orders requiring the Chief Constable to attend personally to explain the non-arrival of certain documents. This is a not uncommon experience on the circuit. And then, of course, the parents are very often in a very difficult position because they will also have criminal lawyers giving them very different advice. And although the jurisprudence is quite clear on this, that is irrelevant to care proceedings, and there is an obligation to put your story, it's still, where you have people of perhaps limited understanding and education, that is a very difficult situation to be in. So, my lady, yes, in an ideal world, yes, within a matter of, say, 2 or 3 weeks of the ABE interview, somebody could say to the child, well, so-and-so says this is what really happened. What do you have to say about that? In an ideal world. But they haven't even managed to achieve that in criminal proceedings.
Well, no, my point to you is there are reasons in criminal proceedings why they can't achieve it,
Yes.
because people are entitled to keep their powder dry.
Yes.
To a certain extent. That doesn't apply in care proceedings.
No, it doesn't.
They're not entitled to keep their powder dry. They're compellable witnesses as to what happened, and therefore subject to the availability of the facilities.
Yes.
There is really no reason at all why a series of further questions giving the alternative account of events
Yes.
can't be put to the child
Yes.
in the same sort of surroundings to which the child is used,
Yes. Within a short period of
within
time.
a
relatively
comparatively short period
yes.
of time, while everything
Yes.
is still fresh in everybody's mind.
Yes. And then that can simply be recorded.
Yes.
And then everybody could see it. In an ideal world, lady, yes, absolutely. That would answer the situation as to the obvious lacuna when there is an explanation, rather than just saying, well, I didn't do it, but there is an explanation
Yeah.
that the child should hear and be able to comment on. Yes. It would, of course, require not only the availability of the the ABE interview and the police evidence and the facilities that the police have for recording these interviews, But of course, it would also require funding in other ways, as obviously this kind of questioning would have to be done by the appropriate lawyers, presumably, rather than the judge. And of course, there's no provision for funding of that at the moment either. So it would require considerable change. But, Milady, yes, that aspect of Pigott would seem to be eminently suitable to children's proceedings. Milady, the only other point I wish to address in relation to matters not covered yesterday is the point raised about the difference between party children, subject children, and children who are merely witnesses, of course, all of whom have article rights as a matter of course.
But the party children and the subject children have got Article 6 rights.
Yes.
Because it's determining their civil rights.
Yes.
What Mr. Geekie calls stranger children.
Yes.
Have, well, Mr. Geekie conceded they had Article 8 rights. It was, I think, quite big of him so to concede. But he did. Yeah. But they're obviously of a different order from the rights of
yes.
the people whose interests are at stake in the proceedings.
Yes. And of course, absolutely, they don't have the interest in the proceedings. I mean, the kind of child who is merely a witness, apart from the obvious complete witness, who's a complete stranger, who sees something, is for example, a child who claims that they have been previously abused but is not part of these proceedings, or a friend of the party child or the subject child who claims to have been abused. And therefore they do not have, very often they do not have the degree of personal involvement and emotional involvement in the matter that of course makes things so difficult for a party child or a subject child. And of course also very often they are likely to be better supported by their family, which is the problem with party children and subject children. Subject children, where you're in private proceedings, of course, are caught completely in the middle of family conflict. And they are in a very difficult position because they have no guardian to support them, or rarely have a children's guardian to support them. There is less likely to be an ABE interview and more likely to be allegations between the parents as to the child being used or abused and put up to things and being required to say things or make allegations. And of course, a huge problem for the child being stuck within family conflict in terms of what a child needs as opposed to what an adult needs, in terms of its developmental needs and its attachment needs in relation to its parents, in deciding where its loyalties lie and where its security lies and where its safety lies. So as a subject child in some respects is almost in a worse position than a party child, even though they may well be still living within the family and with a family member. And that is a matter of, we would submit considerable anxiety to the court, that in those circumstances you are unlikely to have an ABE interview. Thank you. And therefore, if the child were to give evidence, it's then in a position of giving all of its evidence in court. But without the child giving evidence, you have people making notes of what the child says rather than an ABE interview. So that is a very difficult situation. And one way to assist with that would be to broaden the circumstances in which ABE interviews are done, rather than simply at the moment as they are done primarily by the police for the purpose of criminal proceedings, so that the court can ask for ABE interviews to be done in proceedings that are not care proceedings and where there are no involved criminal proceedings. But again, that's something that doesn't exist at the moment. But again, the subject child, we say the factors that we have set out in the proposed guidance do also cover all the difficulties likely to be faced by a subject child. My Lords, I believe...
Can I just clarify with you what
Yes.
you mean by the difference between a party child and a subject child?
Well, I'm talking really about a public law proceedings where the child is a party and has a guardian, and where there are frequently criminal proceedings and an ABE interview. And a subject child, I was using that term to mean private law proceedings where you have warring parents.
Oh, I see, that's what you mean.
Yes, I'm so
Yes,
sorry.
yes.
Yes.
Yeah, I thought you were meaning, then I realised you couldn't be, you were meaning the younger children in the position of the younger
Oh, I
children
see.
in this case,
Oh, I see.
who are not the complainants, but they are, of course, subject to the proceeding.
Yes. But they are parties.
And they are parties, which is why I was challenging you.
Yes, yes. Yes, they're all parties.
Yes.
But of course, a
So
child...
they have the support of a guardian, and in fact their evidence is unlikely to be necessary
Oh, indeed.
in that case. You're talking about private law proceedings.
Private law proceedings. Yes, mother and father, sometimes grandmother, rarely a guardian. Allegations made in unsatisfactory circumstances, frequently not an ABE interview, and no video link facilities at the local county court. And a judge in those circumstances endeavouring to make these difficult decisions.
I mean, I know we're speaking here generalities, but I mean, isn't it relevant in our particular case that C, on any showing, is now with foster parents and will not return to the family home? Presumably has support from the foster parents
Yes.
and isn't, so to speak, at risk of returning with the repercussions of having given evidence.
In terms of direct repercussions, possibly not. She doesn't go home and get told off in that sense. In terms of the effect on a child of being not believed and unsupported by important family members, and then being effectively in the care system and effectively excluded from the family, the psychological impact of that really can't be overstated, my lord. But again, that is a matter of...
But that's going to happen either way.
Yes,
That's not going to depend on whether
yes.
she gives evidence orally at the hearing.
Well, giving evidence, if she gives evidence, she's not being believed, although there's some very recent signs of change. She's not being believed by her parent, by her mother, because of course the alleged abuser is her stepfather.
Well, that's slightly changed, hasn't it?
Slightly, yes.
Well, we've seen the letter from the
Yes.
mother's solicitor. We've all read
Yes.
it.
Yes, and there has been one contact, which...
I was going to ask about that.
Yes, the local authority, well, at the risk of giving evidence, milady, the local authority do not consider that to have been successful. That the child was very anxious to talk about her life to her mother, and the mother was very unresponsive. And the local authority are, frankly...
Well, we're not making judgments
No.
about that, but,
No.
but in the papers that we have seen, contact between Charlotte, we're calling her, and her mother had been stopped by the local authority because they thought that it was the mother's response was damaging to Charlotte,
Yes.
as I understood it.
Yes,
So you're saying there has
Yes.
been one meeting? at
there has
least.
been.
Is Charlotte still seeing the littles?
She is.
Yes.
She is.
Thank
But
you.
of course, the implications for Charlotte of the proceedings and giving evidence, of course, puts her right back in the middle of the proceedings are huge because she's also of an age where she is aware, very much aware, that they're all scattered in foster care, and there is always the possibility that they will be further scattered as a consequence if these allegations are proved and the situation as it is at the moment doesn't change, and that she is responsible for that. And she will also, and this is something that does arise, is facing cross-examination, or the prospect of cross-examination from a stepfather who is not your real father, is actually quite a different thing to facing cross-examination from a real father or on behalf of a real mother, who, of course, from a child's point of view, are the very people who should be looking after you and protecting you. And these are all psychological factors that these are perhaps form part of what the Court of Appeal called the big issues, the big questions that need to be considered before making any extension to the question of children giving evidence in family proceedings. Essentially, my lady, because children are children, because they do not think and function as adults. So from the point of view of this child, in practical terms, yes, she's in foster care, and yes, she's unlikely to suffer any direct repercussions that might come from coming into contact with some people. But that really is barely scratching the surface of the potential psychological ramifications for a child in her position. My Lords, unless I can assist you any further, I was going to, in respect of this particular case, my learned junior is proposing to deal with that in respect of where this case should be dealt with.
Thank you very much. Miss Early.
Thank you, my Lord. So I'm just going to move, so I'm not going to reach the lectern. So hopefully you can hear me as well with the so apologies. My Lords, it's a particular concern of the local authority, and no doubt a concern of my Lords as well, as to what the consequence of any decision your Lordships might make in respect of Charlotte, and how the ramifications might be in respect of Charlotte and the process in respect of this fact-finding hearing. As my Lords are no doubt aware, this case is currently listed for a fact-finding hearing to commence on Monday, with a time estimate of 4 or 5 days.
We have that very well in mind.
Thank you. And no doubt my Lords also have well in mind the fact that that will be the third listing of this fact-finding hearing. It originally being listed in November, but adjourned because of late disclosure from the police, then listed for hearing in January, and again adjourned because Charlotte had made new disclosures which form the substance of her second AB interview, which my Lords referred to yesterday. My Lords will no doubt also have in mind the fact that Charlotte and her siblings have been in foster care since June or the beginning of July of last year, so for them some considerable time, and also that a new baby is due to be born in March to this family, and obviously urgent decisions are going to be need to be made about where that baby is going to be placed upon birth. What I would also urge your Lordships to bear in mind is what Charlotte has recently expressed to her guardian, that she is frustrated that everything is taking so long. And one, of course, can see quite why when we put it that this is the third time next week that this fact-finding hearing is due to take place. Considering, of course, what decision my Lords are going to reach in respect of this case, and in respect of Her Honour Judge Marshall's judgment in respect of whether Charlotte should give evidence, and also the Court of Appeal's comments and criticisms in respect of Her Honour Judge Marshall's judgment. My Lords will have to go on to consider, in my submission, what factors Her Honour Judge Marshall looked at, and, if necessary, cross-refer that to both our suggested guidance that should be given to judges, and also, of course, any guidance which your Lordships consider appropriate to draw up in respect of these cases. Her Honour Judge Marshall's judgment can be found in Bundle 1 of tab 8, my Lords. And no doubt my Lords have seen this and seen the decision that Judge Marshall reached that Charlotte should not give evidence.
I think you can assume we've all read the judgment several times. Yes.
Cross-referencing Judge Marshall's judgment to the suggested guidance from myself and my learned friend Miss Davis in respect of guidance to be given to judges, it is in our submission that even if my Lords were to adopt our new guidance, then my Lords can be satisfied that, applying that, Judge Marshall would not have come to a different decision and therefore her decision that Charlotte should not give evidence can stand, and that the fact-finding hearing can take place as intended next week. My Lords, looking at the proposed guidance, it is our submission that Her Honour Judge Marshall, in her judgment, expressly considered all of those factors listed at 1 to 11, and if your Lordships require, I can take you to the specific point, but if not, where we say she has not specifically considered the proposed guidance is only in respect of the support that the child has from family and other sources, and 5 and 6, the passage of time and the likelihood of any further delay. It is our submission that a careful consideration of Her Honour Judge Marshall's judgment would show that she has considered all the other factors in our proposed guidance. And in respect of firstly, the support for Charlotte, of course we say this is relevant because in Pigott, my Lords will no doubt recall, it was expressly said that is one of the factors as to whether or not a child is likely to be traumatised by giving evidence, the amount of family support that that child has. When your Lordships go on to consider the fact that Judge Marshall did not expressly consider the amount of support that Charlotte does or does not have, we say a simple conclusion can be reached that she does not have family support, and therefore that is a factor that militates against her giving evidence, and not a factor we like to conclude that she should be more likely to give evidence. In respect of the passage of time and the likelihood of further delay, again, in our submission, although we cannot say that Judge Marshall expressly considered those factors, we say that a consideration of those factors would be, in the circumstance of this case, neutral to a decision of whether Charlotte should or should not give evidence. And therefore, as said, your Lordships can be satisfied that applying the new guidance, no different decision would have been reached by Judge Marshall, the decision she made back in November that Charlotte should not give evidence. In the event that my Lords decide, as Mr. Geekie requests your Lordships too, that the presumption that a child should not give evidence, if we're calling that, or a principle or a guideline, if we're calling it that a child should not give evidence because of the known harm that is caused to children by being cross-examined. If you are with my learned friend Mr. Geekie on that point, then of course you have to go on to consider whether in those circumstances the presumption or guideline is removed. However, Judge Marshall's decision can still stand. It is, in our submission, impossible to put yourselves into the mind of Judge Marshall and say how much she was influenced by that guideline in reaching her decision. What we would ask your Lordships, therefore, to do is to consider whether you are able to exercise the discretion yourselves on the basis of whatever factors or guidance you consider appropriate in these cases. And we would ask your Lordships to do that, bearing in mind the starting factors that I set out at the beginning of my submissions about the fact that this is the third time this case has been listed and the impact of further delay on both Charlotte and her siblings. We would ask your Lordships to exercise that discretion so that there will be no further delay in this case.
In that respect, the judges was obviously much better informed about the background and the facts and so on than we are likely to be, and had seen the first interview on video, presumably.
She had seen the video.
I mean, is that an advantage for the judges? Doesn't that give her a better feel than we would have?
I would accept, my Lord, of course, that in ideal circumstances, the tribunal who is exercising discretion should see the AB interview if there is one. The circumstances of my submission are slightly different in this case because your Lordships can draw from Her Honour Judge Marshall's impression of that in respect of Charlotte going out on a number of occasions because she said she had tummy ache, for example, but you'll recall that Her Honour Judge Marshall made no further findings in respect of C's presentation that she's an articulate, intelligent 14-year-old, which is accepted by all the parties before the court. There's nothing else, we say, that Her Honour Judge Marshall found as a fact in watching that video that is relevant to the exercise of the discretion.
I mean, has Ms. Marshall looked at this case since the second ABE interview on the 13th of January? And she's bound to have to exercise a fresh discretion, is she not, in any event? I mean, even if the matter was to go back to her, she would need to consider that. Has she done so? We've no reason to suppose she has she?
I understand that all parties envisaged the fact finding was to take place next week. All parties have been served the ABE interview of the second ABE interview of Charlotte. No party has resumed their application for Charlotte to be called to give evidence before the court next week. So, as my understanding, it hasn't been relisted before Judge Marshall. If, for example, the father, in light of the second ABE interview, was saying he didn't accept the new allegations and therefore that supported his application to call Charlotte to be cross-examined, in our submission, he should have made that application to the court in knowledge of the fact this case was listed for a fact-finding hearing next week, and no application has been made.
Oh, well, I didn't understand about that. I mean, so are you saying that this court can safely work on the basis that the father is not interested in cross-examining in respect to the second ABE interview?
Well, the court can, and no doubt Mr. Geeky can address you on that, but the court can assume on the basis that the father has not made any application to the trial judge in that respect, and one would expect him to have done so if he was likely to renew that application, knowing that the fact-finding hearing was listed for the third time next week. One could have... Sorry, Your Honour.
He wants to cross-examine Cheyenne.
But he hasn't made his application.
Of course, Judge Marshall herself raised the question of whether Charlotte should give evidence. If she becomes aware that there is a second ABE interview, is she likely, again of her own motion, to say that she ought to revisit the question?
She is aware, the judge is aware, because the issue was raised before the judge in January and the case was listed for the second fact-finding hearing. The second fact-finding hearing was adjourned because on that day it was made clear that Charlotte had made further disclosures that needed to be subject to an ABE interview. It was subject to directions before Judge Marshall because the police were saying at that stage they wouldn't be involved in the ABE interview, and therefore the local authority had to get directions from the judge to direct the social workers could carry out that ABE interview on their own.
But
so
she hasn't looked at the second interview.
Well, it would have been filed at the court, but certainly no party, neither judge, has asked for directions to take place before the fact-finding hearing that's due to take place next week.
There were directions, but I don't know.
Didn't take place. The matter was last before the court, I'm told, on the 12th of February. But my understanding is that was listed for a contested interim care order at the request of the mother. It's slightly off point because the mother was saying that in light of her changed position, in saying that she now believed some of what Charlotte was saying, that there was reason to argue on her behalf that the children should return home and be placed with her.
Is she now living apart from the
She
father?
says they've now separated. The local authority, to be fair, is somewhat sceptical as to how concrete that separation is.
Is he still in the caravan?
I think he's now in London, I believe. He's moved to London.
There was an exclusion order in the early days, and he went to live in a caravan. Then, of course, the children were put in foster care, so we don't know what's happened to him since.
No, we're told he now lives in London.
And nothing happened effectively on the 12th of February, did it?
I understand that the interim care order was not contested and that no concrete directions or important directions were given other than that the fact-finding would take place on the 8th of March, so next week.
Right.
Of course, the facts that the local authority once found are all relating to the sex abuse allegations.
Well, that was the original local authority's threshold criteria, if I can call it that, or schedule of findings. The local authority have now filed an amended schedule of findings, which does include the issue of domestic violence. But it's fair to say that the issue of domestic violence and physical abuse was not raised for the first time in Charlotte's second ABE interview. Two of the children, the other siblings, raised it when they first went into foster care. So it's not a new part of the case.
So have we got the amended schedule?
It's not part of the appeal bundle. Yes, and I understand from my friend Mr. Geeky that those representing the father have not seen the amended threshold document.
Is the fact-finding exercise likely to proceed if Mr. Geeky's client hasn't seen the amended schedule?
Well, my lord, clearly that will depend on what is in it, the extent to which it takes Mr. Geeky and his client by surprise, whether it's just further delineating the facts that were known to all the parties in any event. The local authority likely to argue it was, given that these were disclosures or allegations made by two of the children when they initially went into foster care, and given that Mr. Geeky and his client have seen the content of Charlotte's second ABE interview. So nothing in there should take them by surprise.
I think you want to get it to Mr. Geeky's solicitors as a matter of urgency.
Of course, my lord, and that's something we hope we can arrange today. I'm told it's been sent through solicitors, but maybe it hasn't reached council.
This is quite taking me back to everyday life in family proceedings, where new things come out of the, newish things come out of the woodwork all the time, and you simply can't fix on a time when nothing new is going to happen, and because that's not how children's lives are.
Yes, Marlene, I had some factual information to give the court in respect of where this case would go were it not to take place next week, because we've made those inquiries. So your lordships can put it in the context of what the likely delay is going to be, both to Charlotte and her siblings. We were told from the Portsmouth listing office that if the case did not take place next week, but was still to remain before Her Honour Judge Marshall, it could take place in May, or likely to be able to take place in May.
Do you have a date in May or not?
No, just May. We also made inquiries with listing at the High Court if this court considered it appropriate not to remit it to Judge Marshall, but to a judge of the Family Division. And we're told that the listing would be in October unless it was felt appropriate to give it a vacation listing, in which case it was likely that a listing could be found in August or September. The local authority, of course, would say in that regard, it would be the summer, 2 points. Firstly, these children have then been in foster care for a year before the facts have even been determined, which of course is stage 1 of the care proceedings, before we go to stage 2 of the care proceedings to determine where these children's future lies. And if we reach the summer, we're then in the stage of also coming up against the criminal proceedings, which we understand are likely to take place in the summer, and therefore...
I think, Ms. Elliott, we all have very, very clearly in mind that it is most desirable for this hearing next week to proceed.
Thank you,
And I don't want to stop you,
No.
but I assure you we really do have that very well in mind. And I think some of the things you've been telling us show that these delays happen, and it's never any one party putting up their hand and say it's all down to me. They happen because life is unpredictable, and we've got to do the best we can to push this case forward.
Thank you, my lord. That's very helpful. Can I assist your lordships any further in respect of Charlotte specifically and where this case is going practically in terms of the fact-finding listing?
Well, we're still looking forward to hearing from the Guardian, who
Yes,
I dare
of
say
course.
will have more to say
Yes.
about that. So unless there's anything that you want to say on behalf of the local authority, thank you very much.
Thank you.
Yes.
My Lords, I think realistically anyone practising in this jurisdiction has become increasingly aware of the tensions that are between the different ways in which children are treated, particularly as between crime and family. And trying for myself to track through where that unease derives from, I think principally I'd identify two issues. I think first is the recognition that from a legislative and policy perspective, special measures have undoubtedly improved the situation that was identified by Pigott. without any doubt at all.
There was a time, I mean, I was at the bar a very long time ago, when quite a lot of practitioners practice both in crime and in family, but my impression is that is quite a rarity nowadays.
Yeah, I have to say I'm that rarity, in fact.
Right.
And the position that I'm in is that I prosecute and do care proceedings and to defend and represent parents or children in abuse cases.
Well, we're
basically.
very lucky to have your shared experience of the two fields.
And interesting, I've also been on a jury in the last year where we had 2 children's cases. So it was actually very interesting seeing it from that side of the bench. And also, really interestingly, how much more disturbing it was sitting in the jury box, watching it happen from doing it yourself or watching another practitioner doing it. It felt qualitatively different being in the jury box from the bench, which I can't explain in any way, but it was a very interesting exercise. So from that point of view, anecdotally. I don't think I'm in any doubt from my personal experience that special measures have moved on things enormously. And I think if you do practice cross-jurisdictionally, you do frequently ask the question, why is it that we're approaching this really from polar parts? Clearly, the legislative framework operates in that way, and I've identified that in my case statement. Clearly, the objectives are very different. But I don't think any practitioner would suggest that special measures have moved things on enormously for children giving evidence in court.
Would suggest or would deny? You said, I don't think any practitioner would suggest.
Anyone would deny
Yes.
that has been the consequence of it.
Sorry, I'm now lost. Just say that again.
Yes, I don't think any practitioner would deny that the introduction of special measures has improved the situation for children giving evidence, just as a very general proposition. It has to be quantum leaps different for a child to be doing it via video link than confronting counsel in court. And so I think that's where the practitioners come from. Special measures has been a good introduction, has moved things forward. The reason I say that measuring up makes interesting reading is because it comes from a different perspective. The practitioner's perspective is one thing. The perspective of the child going through the process is a completely different thing. And I'm going to take your lordship shortly to 2 or 3 passages which we say are worthy of particular note within measuring up. Because from my perspective, reading that document, the perceptions of children are clearly different from where I would say that the practitioners are. The other specific reason why I think this overall issue has become increasingly troubling is because of the huge increase in fact-finding hearings. When the 89 Act came into force, I struggled to recollect any significant hearing where we spent a lot of time looking at the factual substrata. Now, that may have been a wrong approach, but that was the way it was. And much more of the hearing was concentrated on welfare and the future of the child. I think rightly we've come to recognise how important the factual substrata is to the future decisions for the children. But that increase in fact-finding hearings, I think, has shed a spotlight onto this particular issue. And we would be saying to the court that it's important to look at this issue not just in the context of Section 31, but in the much broader context of family proceedings generally. And our overall submission is that, in fact, the issues that this court is being asked to consider, and indeed the terms of reference to the Family Justice Council, actually throw up far more difficult issues in the private law arena than they do in the public law arena. And I shall develop that shortly to explain why I say that. I think the third issue for practitioners is that there is a real unease about the rigid way in which the current jurisdiction has been applied to children at the upper end of the scale. And Mr. Geekie took you to R&B County Council at tab 7 and highlighted the concern that...
This is the 1991 case, is it?
It is. And if you remember, your lordships were invited to consider the very real concerns that were being expressed by Lord Donaldson and Lord Justice Nichols in relation to the outcome which was attendant on the application of the principles. And can I perhaps just look at Lord Justice Nichols' judgment? I've got it at page...
7 of 10.
My Lord, thank you very much. And the first three introductory paragraphs say nothing that's controversial, but what we do say is that what is quite clear from the fourth paragraph, the last paragraph on that page, is that Lord Justice Nichols was being very specific about the disquiet that had arisen in that case. I do not read this judgment as Lord Justice Nichols saying, I am very concerned about the application of this jurisprudence to children as a generality. What concerns me is in this present case, this child is now aged 17 years and 3 months. In the normal course of events, I would have thought that fairness and best interests march hand in hand with requiring the veracity of her statements to be established. And the same sort of concerns occur over the page for Lord Donaldson. And his second paragraph, again, reservations around this particular child at her particular age. And in a sense, those reservations reflect where we know where we are on special measures, because, of course, children broadly fall out of special measures at 17. And we will reflect in due course that for children at the upper age of the scale...
So, do you mind if I ask you something else about
Yes.
the case, which it isn't on what you're talking about, but in that case, the alleged abuser, the stepfather, wanted Jay called. She was the girl of 17.
Yes.
But the case seems partly to have been decided that the local authority wasn't going to call her, and that decision couldn't be judicially reviewed.
Yes.
And that the stepfather couldn't really sensibly call her as his, take out a witness summons and call her as his own witness, because he then couldn't then cross-examine her. Now, that seems to me, from what I know of this case, to be a feature of this case, but it hasn't been mentioned at all. Whose witness Charlotte actually would be if she were called.
When the issue was raised on the 21st of September, and from, as I, and again, this is my first involvement in this case, so I'm sure I'll be corrected if I've got this wrong. The case was listed on the 21st of September to deal with what was apparently a disputed application for disclosure from Hampshire Constabulary. And in fact, they were represented on that day. That objection fell away, again, as I understand it, outside court. And so the matter went into court on a general directions basis, and it was during the course of the discussion that the local authority indicated that they were proposing to call C in effect because they had no other way of proving their case. And of course that was technically right at that stage because there was no forensic evidence and so on and so forth. The Guardian was very troubled about that indication. She was slightly hesitant, partly because she'd been out of the arena for 4 years and had just come back in and wondered if there'd been a seismic shift in jurisprudence. Took advice from her solicitor, who I think would frankly say on reflection, he should have said, I need to think about this, but reacted to the situation he had. And then the suggestion came forth that in fact it should be the Guardian who should call C, if she was to be called at all. Now, my understanding was that the preamble to the order which recorded that C was going to be called to give evidence did not indicate by whom. Judge Marshall, of her own motion, struck the preamble from the draft order and listed it for a contested hearing on the 23rd of October. And so a long-winded answer to your Lordship's question is that there, as I understand it, had not been a resolved position, but the suggestion certainly was that it was going to be the Guardian who would tender C for her evidence. Can I say anecdotally, a case I did in Swansea last year where a 17-year-old was called to give evidence, was called by the local authority. She had undertaken an ABE interview but had made subsequent disclosures, much as your ladyship has already identified a rolling situation. The local authority called her and led the new evidence, and I don't use led pejoratively, they adduced the evidence. And in fact, what happened in that case was that 2 questions into my cross-examination, having identified that I was for the stepfather, the witness left the video suite, never to return. And the 2 questions she'd been asked were about her family and completely neutral. So that was my experience anecdotally then, that it was the local authority who'd done it. But I think we would see in this case that it probably would be more appropriate for the Guardian to lead that evidence, bearing in mind the Guardian and her solicitor have struck up a good relationship with C.
Is there anyone who could compel you to call it? I mean, how does it work?
Well,
because basically, Mr. Geekie wants to ask questions. So is there anyone... I mean, I suppose the answer is that someone is putting in the child's evidence because it's on the in the interview, and yes. So you'll be entitled to, normally.
Yes.
Isn't the ABE evidence the evidence in chief, in effect?
Yes.
Oh, absolutely.
Well, actually, technically, I suppose it's not. I hope these technicalities are not going to dictate the substance of this very difficult and anxious decision. But whereas it is expressly provided that the video of the ABE interview will stand as the child's evidence in chief in special measures, and was in the Criminal Justice Act of 1991, what we have is simply a blanket admissibility of hearsay. Yes. So basically, it's somebody producing this video as an exhibit, as part of their own evidence. That's, I think, the technical situation.
I think that's
right. I'm not in much doubt that the court can direct the Guardian to call any witness that the court wants the guardian
absolutely.
to call. I mean, that's common practice.
And that's where I would see it would be appropriately led from, particularly in this case. But to deal with the question of enforcement, and of course it's a question that I address in my case statement, and I don't think I have for myself reached a resolution, because the authorities that provide the principles that we've identified arise in the context of applications for witness summonses. It doesn't arise in the context of an application to call the child. In each case, what is happening is that a party to the proceedings is seeking to compel the witness to give evidence. And of course, that's where we get the oppressive description from, because of course the test on the summons is whether the issue of the summons is oppressive, not whether the calling of the child is oppressive. And I think that's one of the reasons that we don't have as much clarity as I think we need to have about the circumstances in which children might be called to give evidence. And I am concerned about enforcement, and I'll hopefully say quickly for which reason. If a court has, in response to an application by a party, indicated that there is a particular reason, an exceptional circumstance, whichever test you're going to apply, but passing that test, it is right that a child should give evidence in family proceedings. What is actually the consequence thereafter of either a refusal by that child to give evidence or an inability to give evidence, in that the child attends at the court, perhaps sits in the room, finds that 3 questions in, it's completely incapable of completing the task? What inferences is the court then to draw from that position? Because if you've got a piece of evidence from a child which the court said there is no particular reason for this child to be called to give evidence, you attend to it carefully, you give it such weight as seems appropriate in the light of all the other circumstances. But if you in fact have made a decision that says it's right for this evidence to be called and tested orally, where does that leave you in the event that the child won't cooperate, can't cooperate? And that has really troubled me in terms of the inference that you then take into the family proceedings. Because, of course, within the criminal proceedings, the outcome would be an acquittal, and rightly so. But that, it doesn't seem to me, translate into family proceedings with any ease whatsoever. And so it's that sort of consequence that has troubled us on behalf of the child, is where you take the position if you're going to say, yes, a child must give evidence, and then it can't.
Well, we wouldn't ask for this. I mean, assume it's a borderline case, and there it is. The judge, perhaps not least for that very reason, thinks, well, we better just see what this child is, whatever it is, 16, 17 years old, say, as in your case whenever. And then the child, you know, perhaps for entirely understandable reasons, can't take it. Well, I mean, one can imagine that in that situation it would be appropriate, would it not, for the judge to say, well, I'm terribly sorry, this child may very well be speaking the truth, but I can't be sure on the balance, even on the balance probabilities, that that is so.
I think respectfully, we risk then putting the protection of the other children at risk. I think this is a really difficult, because I think there are natural consequences that you would say, well, that would flow from it. But on behalf of the child, I'm very concerned that if we put in place a framework which has an expectation behind it, we elevate that evidence in a way that puts other children, either the subject child and or its siblings, at risk when under the current situation they would not be.
Well, is that right that they would not be? Because, I mean, I thought that was precisely what the current situation was. Going back to the case you referred to, R and B, ex parte P, Lady Justice Butler-Schloss said, quoted the stipendiary, who said, "I'll have regard to the gravity of the allegations and the fact it wasn't tested by cross-examination." She said, "I'd like to endorse those comments." I.e., hearsay evidence is admissible as a matter of law, but you look at it with caution. So you are in a situation where, under the present law, judges are supposed to direct themselves that it may be necessary to give less weight, even significant less weight to it, although it's entirely admissible as of right, as you point out.
I think my concern comes from the next step on.
Yes, but why does it follow? See, it may very well be, the judge has seen what happened.
Yes.
The judge knows all the other evidence in the case.
Yeah.
And we're talking about masses of evidence.
Yeah.
Of course, part of the problem with split hearings is that the judge is denied rather a lot of evidence that the judge ought to have. So I'm not a fan of split hearings myself, that must be apparent. I mean, they're good in some respects, but they're very, very bad in others. But there is a lot of material there. Isn't the judge the best person to work out, did this child run away because this child couldn't cope with the situation? I.e., it was all too overwhelming and too upsetting, and the child was being made to relive very painful situation. Or did the child run away because the child couldn't face being exposed as a liar? Yes. Isn't that a judgment? But aren't the inferences a matter for the person who's seen and heard the evidence in the light of all the other evidence to draw, not your knee-jerk, what would I do if a 40-year-old man ran away from the witness box? Yes. We're supposed to understand children in these cases. That's what they're about.
Yes. Well, I respectfully agree. I flagged the issue because I am concerned about it, because if we start from Mr. Geeky's level playing field and we have a determination that a child should be giving evidence in any given situation, are there inferences to be drawn then from the child's inability or refusal to give that evidence? And as I say, it's not a question I've really formulated an answer to, but I do think it's problematic when you come to exactly the point that my Lord raised, which is how do you force that? How are you going to move that forward? And I think that is a real issue within family proceedings. I don't put it forward as a major issue, but I have flagged it in my case statement, and I do think it's got to be considered in the overall context of where we are.
Well, however experienced and careful a judge is in forming a view, this seems to be an intelligent, composed 14-year-old. There must always be a risk of total collapse with a child that age. And the judge has got to do the best she can, isn't she? I mean, nobody's going to suggest the child should be punished for contempt of court or something because she can't stand it.
It's not so much that, it's how it impacts on the findings that the judge has got to make.
Yes, I see that.
Yes.
I mean, I wouldn't for a moment suggest any inferences are drawn against. Well, my only concern is if it's a borderline case, it may leave the judge still in a position of uncertainty.
Not being able to take the matter forward.
But that will be true in the positive situation if the child didn't give evidence, because the judge would again be saying, well, I haven't
heard.
It's heard from the child directly. I haven't seen the other side put to the child, however gently or sensibly or firmly or whatever is the right way to do it. So I'm going to have to approach that evidence with a much greater degree of caution than I would do if that had happened. Yeah. That is, as my Lord points out, already the law. So in a way, it doesn't make much difference, does it?
I suppose the only category of child that then would cause real concern is the one, and let's take C as this example. If this court or another court were to say C should give evidence within these proceedings and her guardian goes to her and she says, I'm not going to do it. Undoubtedly, that refusal is going to be an issue for the father within those proceedings, and it's how that refusal is going to be treated and how you go about assessing whether that's a refusal because the allegations aren't true or because they can't face it. Or it's that sort of situation that I think we're quite concerned about on behalf of the child.
Are you going to tell us at some stage what the latest view of the Guardian is about Charlotte's state of mind? I mean, we've been told by Miss Earle that she's frustrated, which is entirely understandable.
Yes.
I mean, in due course, you'll come to that.
I'm certainly going to address that in due course. Could I just take a few moments to just think about private law proceedings, because this is an issue which causes CAFCAS huge concern. Section 31, parties, parents, non-means tested, non-merits tested public funding. And so unless there has been a spectacular breakdown in communication, it is the norm for the alleged abuser to be represented through counsel or indeed experienced solicitor advocate. That is not the position that we face day by day in private law proceedings. Increasingly, and your lordships will be fully aware of this, there are very few private law litigants who qualify for public funding, and so it tends to be those who can afford to pay or those who fall right under the benefit line and are able to claim public funding. Most of these cases are now done with at least one unrepresented parent. And as was rightly indicated earlier, allegations of sexual or physical or indeed emotional abuse made within private law proceedings are frequently not the subject of ABE interviews for all sorts of reasons. Family want to keep it private. Certainly, we are absolutely familiar with the sort of last throw of the dice. I'm going to make sure that this parent doesn't have contact with a false allegation of sexual abuse. Who is going to call the child? Is the child going to be called by a parent to give evidence against the other parent? Because frequently the child won't be represented within the private law proceedings. If that's going to happen, do you appoint a Rule 9.5 guardian so the child is represented, but how then do you deal with the cross-examination of that child? We think there are really serious issues which arise in the public law arena. And ironically, we would say it's an arena in which you're more likely to find allegations being fabricated.
You mean private law? Right?
Private, I'm so sorry, private, yeah. That's the arena where you're going to find the fabricated allegation, the embellished allegation. The fact-finding in private law is a very, very difficult task, which is carried out extremely well by the district judges up and down the land. But the fact of the matter is that the resolution of, say, an allegation of sexual abuse within the private law arena as it stands risks the child being called and or being cross-examined by a parent, which in our submission would be wholly unacceptable.
By a parent in person, because the criminal law prohibition doesn't apply.
Quite.
Yeah.
And all this is within the same statutory instruments, is it, which make hearsay evidence
Yes.
admissible automatically?
Yes.
Yes.
Yeah.
Yes.
And I have to say, but I mean, quite understand why in relation to this specific appeal our attention's been on Section 31, but I think it's important that we recognise that the decisions here are going to have a far, far greater import than in a sexual abuse allegation in Section 31.
But the inquisitorial nature of children's proceedings applies in private law proceedings as much as it does in care
Yes, it
proceedings.
does.
There may not be authority for that proposition, but it's obviously correct.
Absolutely.
I don't believe it to be controversial. Mr. Geeky will tell me if he thinks it is. So the judge would, or the court, would be in charge in the same way
Yeah.
as to what to do about a particular piece of hearsay evidence and how to arrange for it to be challenged if the judge thought that that was necessary in the circumstances.
But in terms of, if you set, and I think we're very much in line behind the local authority in terms of favouring some clarification from this court about the current position. Those considerations will apply equally in the private law arena. And I do think we have to have strongly in mind when there is a suggestion that there shouldn't be a starting point. And I think it really goes to that point. If you start with a blank canvas, as suggested by Mr. Geeky, and you just factor in all of the issues as you go, we think there is a real risk of importing into the private law arena a completely inappropriate involvement by the child in the evidence building process.
The issue comes down to this, does it not? The question is whether the erection of a presumption is the most efficacious way of protecting the child's interests.
Yes.
I mean, an alternative way of looking at it is to say, well, of course, in every case, the risk of a child being damaged will loom large and therefore must be given very serious consideration in every instance. In that way, you're not constructing a presumption. Presumption inevitably means a skewing of the litigation in favour of one, not necessarily one party, but one outcome. The question is whether it's better, rather than doing that in an arguably artificial way, it's better that you recognise that in every case, the risk of damage to the child, whether it be the trauma involved in giving evidence or it be the undesirability of being cross-examined by its own parent, that will always be a matter to be given very serious consideration.
Well, we think, with respect, that the better way, and we are not in our submissions going to be suggesting there should be a presumption. We are saying there should be a starting point. And
what's the difference?
Well, it may be, but in a sense, are we looking, when it is said inevitably in that exercise, the damage to the child of giving evidence is going to be an important weight in the balance, are we not there making a distinction without a difference? We would say it's far better from the child's point of view to be upfront about it. We say that it isn't possible, with respect, to have a level playing field in circumstances such as this. If you've got adult competing litigants with their different cases to run, absolutely the same considerations apply. But when you are looking at children giving evidence, that is not, with respect, we say, the same thing at all as an adult party giving evidence. And you have to, because of the inherent damage in it, because of that recognition, we do say that you have to put that right at the forefront with all the factors to be balanced against that in place. But we say in order to protect the child in the process, you have to have that as a starting point.
You said, you referred us to Lord Nichols's statement about a child just over 17,
Yeah.
and you said yourself that there was real unease in the profession about the rigid way in which the present approach operates at the upper level of age. Well, that immediately indicates that it can't be the same force in every case.
No.
So if it can't be the same force of every case, why isn't it an important factor, but nonetheless only one factor? in an exercise which actually involves a lot of people's different rights.
Yes, but we would say on behalf of the child, I'm afraid, that there has to be, because of that particular vulnerability and because of the process, that there has to be some built-in protection, and we say that's the best way of doing it. Can I come to the issue of age? Because we flag in our statement of case a possibility that we see, not necessarily for now, but for consideration in conjunction with the Family Justice Council, and I'll explain how we came up with our ages in a moment. But we would certainly say that within the factors to be considered, we can see no reason why a judge should not be told that the way in which to approach the chronological issue is that the older the child chronologically, obviously out with issues of physical, mental health, learning disability, that with age, I'm just pausing because I was looking for the word that I'd written down for myself. The older the child, we say, the stronger will be the expectation that that child will be able to cope with the emotional difficulties of giving evidence. And we say that that should be specifically part of the counterbalancing features. So the older the child, the stronger will be the expectation that they will be able to cope. And we say it's in that way that you factor in age, and that if you simply take out consideration at the very forefront of the decision-making process, that, and I don't think we would dissent with respect from the wording, my lord, that was used earlier, that it was likely to be damaging. We wouldn't dissent from that proposition. But we say that in order to protect the child, to ensure that the process is as fair as possible, and in that respect, it's not just about fairness to the person who's being accused, it's about the fairness of the actual process itself and the results that that brings forth for a child at the end of the day. And we've thought, I have to say, long and hard. And can I say I've had a brief opportunity to talk to CAFCAS Legal and their views about it, and to a certain extent those are incorporated in this document. But CAFCAS overall, and not just about this Guardian, would be immensely concerned at this stage at the suggestion that the situation that we have now, which starts with it's damaging to children to give evidence, that should be displaced in any significant way. We say there are ways in which Article 6 can be respected, even more so than I think obliquely it is now. We do say there are ways in which that you can build in that particular issue about the older child. But we do say that to go any further than that at this stage, without a proper evidential base for it, risks huge ramifications for the child, which, frankly, we're not in a position to assess at this stage. And you'll see from my statement of case that we are very concerned about the child who now, if we go down a track where that presumption, whatever you call it, the starting point, the presumption is shifted, we say that many more children are going to be brought into the situation where they're giving evidence twice. And that's likely to be care followed by crime. in reality, that's how it's working out on the circuit, certainly. I don't know about London, but certainly on the circuit, care proceedings are coming in 6 to 8 months before the criminal proceedings are coming on. We have no idea how
Sorry,
that's...
what's the position you say happening?
On the ground.
On the ground, I apprehend, you're having your care proceedings without the child being called.
Yes.
What are you contemplating as the result of those before the criminal trial? That the accusation is found established on the balance of probabilities or not? I'm asking for what you're telling us about the practical experience on circuit.
The practical experience on circuit is that the first set of proceedings in time are the care proceedings.
Quite. Child not called.
At the moment, child not called.
Result?
Result, by and large, you get some sort of outcome on the fact-finding, and it moves on from there.
Sorry, what sort of result? Are they mostly found that the accusations are upheld? If they're not, are they followed by a criminal case?
Oh, yes. Again, I can only say that this is anecdotally, but my experience is that the police really take no interest in what has happened in the care proceedings. Which, I mean, one has to...
And the CPS don't either?
No. Because all sorts of different parts of the evidence are available in the care proceedings which won't be involved in the crime. We find that there is very, very little cross-pollination between the two. And that's the reality of it. And so at the moment, the child usually knows the outcome of certainly the fact-finding stage, and pretty well knows the outcome for itself before it gets into the Crown Court, quite frequently. But of course, it's only giving evidence once. And it's putting in the additional stage where we say you've got the evidence in the care proceedings, and then the child having to wait to give evidence again in a different forum. We say, we don't know, because nobody's done the work on it, but we say potentially hugely damaging for a child if it's got to go through that process twice. The only way it would normally go through that process twice is if there was a retrial. But currently, a child will only expect to give live evidence on one occasion, and that will be in the criminal proceedings. And we say you have to take into account that potential impact if it's already had to go through the mill once, and potentially then twice. And we say that measuring up actually makes quite depressing reading at chapter 9.
Just remind us what I'm measuring up.
Yes. Tab, I'm so sorry.
No, it's in the fourth.
It's in the fourth bundle, and it's
yeah.
at tab 44.
Yeah.
Could I just, as a complete side note, and while I remember it, we were discussing, I think, yesterday about section 28, which, of course, is the implementation of the second part of Pigott. The reference to what's happened to that appears at page 33 of Measuring Up. And it appears that there was a government announcement in 2004 not to implement the provision on pre-trial cross-examination, based in part on a briefing paper suggesting case processing has dramatically changed in recent years. I think probably a statement of hope, expectation. But my reading of that paragraph was that what was being said is, well, because we've given in principle priority to children's cases, therefore it's not required that we put in this extra stage. That experience is not borne out, certainly by the findings here, and in fact on the previous page. The study deals with priority listing, but unfortunately the statistics which follow, and if we just reference the page number, but 34, they set out the experience of time to trial. Crown Court, I think the 67 months is probably exceptional, but the average time for the wait for a Crown Court trial is 13 months. Between reporting offences and trial. And the statistics are there, and actually they make very gloomy reading, frankly, because Pigott was driven, and indeed every consideration about special measures has been driven on the basis that children need priority and a quick decision. And it's not happening on the ground. That is not happening. And in a sense, I think we do have to reflect that when we're thinking about the broader canvas and how these children are in the care system. But chapter 9, which is the chapter that I just wanted to have a quick look at in terms of children's experiences, and I do say that this makes depressing reading, because round about a third of children experiencing giving evidence are identifying hostility, a lack of politeness, aggression, all those sorts of adjectives from advocates cross-examining them in the Crown Court. Now, of course, that's a matter of perception. And what one child sees as aggression, its parent may see as a perfectly appropriate set of questioning. But
you would equate that sort of perception, though, with trauma. Why does one assume? I mean, children can be quite blunt in their comments without
yes.
feeling trauma about what they've experienced.
Yeah. The problem is, I don't think we've done that piece of work. I think this goes so far, but it does have its limitations, rightly identified by Ms Davis. These are 97% children in families supported by their families. It doesn't deal with the children in the care system. And we would say that this is one of the issues that the Family Justice Council needs to be considering in its steps forward, because we do think that there is a place for a multidisciplinary approach to this. We can see that Dr. Bentovim was very prominent in the discussions that led to Pigott. And I anticipate that that is the sort of evidence that the Family Justice Council is going to have to gather, because I agree that you have the statistic. What is the causal connection into trauma and so forth? And we simply don't know what the answer is. And what we are saying is that until you know that answer, until you've got some indication of what that answer would be, you cannot at this stage take a massive leap forward and simply assume, well, you know, the family division will get it right, people are sensible, they're sensitive in their questioning, it'll all be okay, because frankly, we're not sure that that is the case. And that is why we support the work of the Family Justice Council, I have to say, because we do absolutely agree with, I think it's at paragraph 30 of Lord Justice Wall's judgment, when he said that the time is right for us to be thinking about the possibility of change. We absolutely agree, and we agree for the reasons that I've outlined right at the beginning.
Which part of chapter 9 ought we to be looking at?
Well, I think certainly 9.1 is a snapshot in terms of how people were perceived. It then goes on to consider how children understood the questions that they were being asked. only 50% were saying that they understood all the questions. There's criticism of long words, double negatives within questions. And unfortunately, the whole of that chapter, which deals with how children understand questions, the complexity of what they're asked, their actual experience of being asked questions and the misunderstandings that arise, are dealt with effectively right through this chapter. 9.4 at 115 frankly, I think most of us would look, if you look in the box at the bottom of there, he, the defence lawyer, said, "Do you think I'm nice looking?" I said, "No." He said, "Would you kiss me?" I said, "No."
Well, that ought to have been stopped.
Well,
I mean, that's just ridiculous.
that is absolutely right. And the question one would be asking about that is, how on earth did these questions come to be asked in the first place? And so, whilst respecting the policy and the legislation that is there in special measures and asks us within the justice system to respect, the conclusion of measuring up is that there is a real gulf between that policy and legislation and the actual culture that is working out on the ground. And we do say that that has real implications when we're thinking about the family justice system and the possibility of opening up this area. This has to be put into the balance. Now, whether these statements, these sentiments, these expressions from children actually feed into harm, whether quantifiable or not, is something we simply don't know at the moment. And I think that for us is a real concern. But in a situation where a study such as this is showing that real gulf between expectation and practice, we have to be taking that into account when we decide what is the right way forward for children within the family justice system, when we can see, at least by way of a snapshot, what is happening under special measures. I feel slightly as if I'm jumping around, but the court has heard about the evolution and the real issues, and what I'm trying to do is highlight issues that perhaps I haven't thought about, or I just want to highlight from a different perspective. Can I just pick up on an issue that was raised by Ms Davis, but is a real issue for CAFCAS, which is the practicalities of children giving evidence. And of course, much resource has been applied to ensuring that within the criminal justice system, the facilities are there set up for children to give evidence in accordance with special measures. And where you have a combined court centre, as you do in Portsmouth, we make arrangements to use the Crown Court when, on the odd occasion, a child gives evidence within family proceedings. That's how you would do it. The difficulty is that some of the county courts simply do not have the facilities to implement a special measures type arrangement for children giving evidence in family proceedings. And again, I'm sure I'll be corrected if I'm wrong about this, but just taking, for example, the registry, currently there is one court set up that can receive a video link. And it's not set up for children giving evidence at all, but there is one court, Court 20, has the video link facilities.
This is in the RCJ?
This is in the Principal Registry in High Holborn.
I see.
The way in which that link works is that the witness can only see the back of the judge's head. Because of where the camera is set up, And the fact that you can't manipulate the bench, it's a very small court anyway. What the witness sees is the back of the judge's head, and that is it. There's no direct, unless the judge physically turns round 180, judge can't see the witness can't see the judge's face. And so what's happening is that we're decamping down to St Dunstan's house, where the video link facilities are a little better, but not much, in order to activate the witness link. And in recent case, we went down there, I think, 6 times during the course of 3 weeks. That is, I'm afraid, no way to receive children's evidence, special measures protected or no.
I'm not quite sure where it fits in to the argument. I mean, if the contrary view is that in the interests of justice, actually, you should, in a particular case, be hearing the evidence of the child, it's not a very easy answer to say, well, it just happens that in this part of the country or London, there isn't the facility. There very well should be. And I mean, the reality is that if one's not able to do justice, one simply, the country is simply in breach of the convention. But that's not a very satisfactory answer in the instant case.
No, it isn't. But certainly what we would be saying is that as part of the factors that you've got to take into account, it is not necessarily straightforward simply to say we can move special measures into family because we like the way the arrangement's structured. We've got real practical issues to consider, and that will have to take into account, with respect, the prospect of transfer between court centres. And we only flag it as a practical issue, but again to be factored into the situation, because the family justice system simply isn't set up in a way that makes special measures an easy route to adopt. Now, that's not a reason for not going there, but it is a reason for taking real care about how you deal with these cases and how you approach them. And Kafka's particularly wanted me to flag that up.
We don't have to think only in terms of special measures as they operate in criminal
we don't.
courts, as I think probably said on more than one occasion, because we are here dealing with how the court deals with what is admissible evidence. There are a large number of other things that might be strategies that might be adopted in order to make it possible to put an alternative point of view to the child.
And I think then the question that begs is, do we do that via this court giving its guidance, or do we have to await Family Justice Council to think about...
Our problem is that we've been presented with a question of law.
Absolutely.
The question of law is whether the present guidance gives appropriate weight to the convention rights that are in play here. That is a question of law. Yes. We can't duck it just because we would like the Family Justice Council to provide us with a solution. No,
but it is, respectfully, a question of how far we go down the route and where the line is drawn. And all these are very real considerations within that.
How are things in Wells Street, Ms. Franklin? Just if you're wanting to...
I simply don't know. But I suspect not great.
Well, it's a much better designed court than the...
absolutely. But of course, the sheer volume of stuff going through the registry is, and that again, of course, on a private law basis is a real consideration, because of course that's where the vast majority of that work is done.
Can you give me a ballpark figure for how long it takes roughly from an accusation to a fact-finding session in the care proceedings?
Anecdotally, 9 to 12 months.
9 to 12 months?
Yes. Depending on the complexity of it. I think some centres are getting in the more straightforward fact-finding cases, perhaps in 6.
But in these criminal cases, how long do we think they were? Where do we find that statistic? I've lost it.
That statistic is in...
It's page 34, is it?
Yes.
Measuring up.
Measuring up, page 34.
Yeah, that's right, 34.
Time to trial,
right.
311.
Well, I mean that. I mean, that, the bottom figure there is average. Of course, it's a great range, but average 8 months. So, I mean,
Well,
I mean,
of course, that's from the defendant's first court appearance. And of course,
presumably.
that average time of eight months at
Yeah.
the bottom comes from the defendant's first court appearance.
First court appearance where?
As I understand it, the Crown Court.
I see, not his.
And of course, here, the complaint is made in June and the charge is either the end of September or the beginning of October. I can't remember exactly where it falls in that, but it's after the 21st of September and before the 23rd of October. So there's another built-in 3 months
Charge
within
in
that.
October, yes, I
I think
suspect.
it's, broadly speaking, it is unusual to get a trial of particularly a sexual abuse allegation much under a year
The average
from
is
the date of
13 months, according
Yes,
to
yeah.
this
And so
Crown Court.
my anecdotal experience fits with this. And of course, that in a sense highlights everything that experts and the assessments have made, which is that delay is the biggest enemy in these sort of situations. And it doesn't seem as if we're able to address that. And that's where we are. We have to be thinking about that in terms of impacts on children. Within our case statement, I think we set out the various paths that we felt that the court should go down. And it's fair to say we've refined our thinking somewhat. CAFCAS, on behalf of the child, either this specific child or children generally, recognise how important it is to get, as far as it's possible, the right outcome for the child. That's, in every case, what underpins our thinking. Within the correctness of the outcome must come into consideration the process itself, that the process should not become abusive to the children either who've made allegations or who are the subject of the proceedings overall.
My understanding is that Mr. Geekie accepts that. I may be putting his case on that higher than perhaps I should. He will tell me if I'm wrong.
And respectfully, we do associate ourselves with the comments made by your ladyship yesterday when we were thinking about AB interviews and what underpins those. The whole purpose of that exercise is an attempt to get the best evidence from the child. And listening to the debate, it's easy, in a sense, to stand at a case which has, say, one issue, one serious allegation of sexual abuse, and to say, how is it within that context that a court can make a decision without hearing that evidence tested? The reality is that that circumstance does not often arise because, and again, I feel awful because your ladyship has such a wide experience of it, but our sense is that when you're looking at allegations made by children, it's actually quite rare to find a single allegation case. There are frequently issues of neglect, other types of abuse which may be evident through school or so forth. And so that very stark situation where one identifies that position is a very unusual one to find. And within this case, there is a good deal of evidence, apart from that of the child C in her 2AB interviews, for the court to consider. Various terms have been applied to the forensic evidence that there is, but in short, the child complains of the stepfather taking his penis out of her and ejaculating onto her back. The forensic evidence is that there are lines of ejaculate on the inside of this child's underwear and her skirt on the back. The forensic scientist has been approached, and to her has been put the father's proposition that this could be accounted for by accidental contamination. And the position, as I understand it, is that he suggests that having had intercourse with his wife that afternoon, he removed his underwear and wiped himself with it. That underwear went into the family washing basket, and C's clothes followed it and became accidentally contaminated. The forensic scientist has said that that is an unlikely explanation for... I think it's put in two parts.
I've read the statement.
Yes. And if there are only two competing arguments, it becomes extremely unlikely. That's what she's saying. There's semen on the tissue. We don't know whose it is, but with respect, who else within this family is producing ejaculate which is going onto a tissue?
I didn't catch your phrase. If there are only two competing whats?
Explanations for the semen on the clothes. I think she... Yes, she then elevates that explanation. You have the accounts of the adults who saw her on the 18th of June and the very real distress that she was manifesting. And importantly, you have the evidence of other members of the family. And it is, I think, disappointing. I quite understand why the mother says, I don't have an active role to play in this appeal. I'm neutral on the subject. But it doesn't sit very happily with her recent statement, which says, I think there's something in what she says. But I don't think it's all true. She hasn't actually then specified what she accepts and what she doesn't. But what we do know is that she roundly rejects the allegations of physical abuse and domestic violence. So the mother within the proceedings is going to be cross-examined on her account. There's the question of Natalie. Now, I'm so sorry, N. N applied to become a party to these proceedings. And that application was considered and refused by Her Honour Judge Marshall. I can turn up the date of the order, but it's in the autumn time.
Because the witness statements describe her as a party.
Yes, she is not a party.
She's not a party.
She's not a party to the proceedings.
I couldn't understand why she would be. But
no, or quite. She was represented on two separate hearings. Again, I'm gleaning this from my understanding of it. But the application was refused by Her Honour Judge Marshall, and probably rightly so. But she is over 18. She is firmly in the camp of the parents. She lives with mother currently. Query if allegations made in respect of her by C, she was anxious to become a party, perhaps some thought should be given to her giving evidence. But I think it is important in the circumstances of this case to look at what is surrounding this, because it is not, in my submission, as plain as she says this, he says that. And we do say it's very important also to look at the detail that is attributed by the accused using that word loosely, to the debate. Because if you have a parent who is saying, she's a liar, don't accept any of it, that puts you at one end of the spectrum. If you have a parent who says, well, I remember that incident because X, Y, and Z happened, and there's a different interpretation, or we need to look at the different circumstances, I think that gives a very different flavour to the hearing overall. So there's a lot of, with respect to my lady, a lot of information that's coming into this decision, and respectfully, it isn't just about this child against this stepfather.
I can't understand what the respect to me is. Did I suggest it was or wasn't?
You did say it was, and I'm respectfully adopting it. Your ladyship said these cases are about a whole range of evidence that comes in, and it is extremely unusual in my submission to find a case where there is simply no other evidence bar the two competing accounts. And again, respectfully, if that is the case, as indeed it was in the Swansea case, then the decision was made to call the child. And within what you have as a structure currently, you have the room to do it. At paragraph 47 of our case statement,
What?
47,
47.
my lord, at page 18. We set out what we understand to be the principles at present. Can I just turn to the top of page 19 for a moment? Because I think on reflection, with great respect to Lady Justice Smith, we don't feel that that expression of principle as she saw it is helpful in the context of the debate that we're having.
Which?
Some cases where it's right for a child to give oral evidence, such cases will be rare.
The very top bullet point.
Yes.
Right.
And I think the use of the word rare is unfortunate in the overall context, because I think it does, it touches on a debate that was going forward yesterday, that empirically that may be the outcome. But we do not think it's right to have that as part of a principle, because it puts in a presumption and it sets the bar too high.
We were discussing earlier this morning the second point and the possible modification of that to delete the word undesirable and replace it with likely to be damaging.
Yes, we do not have a difficulty with that at all. So we would say that bullet point 1 stands, that likely to be damaging can be substituted for undesirable. And we've given careful consideration to whether it's exceptional circumstances or another phrase. And I have to say, we favour particular justification. We feel again that exceptional circumstances builds into the starting point a skew which is not justified in the circumstances. I accept entirely that a starting point implies a skew, but it's how skewed does that become? And we think that particular justification rather than exceptional circumstances is the right phraseology in the circumstances of this
So leave
case.
in 3 and strike out 4.
Why do we need the starting point is? Why isn't this just a factor? It is likely to be damaging.
For a child to give evidence in care
Proceedings.
Well, we are clear that children giving evidence within care proceedings require a protection and a respect for, in terms of their position.
They get it as long as you recognise that this is likely to be a significant factor in every case, although you yourself acknowledge that it may be a factor of differing weight in different cases according to a particular age, but maybe other factors, and maybe one would be better informed about that after the Family Justice Council.
Yes, I think that's really where we are. We feel that the removal of that starting point, that whatever you describe it as, we feel that's a step too far at this stage. We still believe that the statutory framework and the philosophy behind the Children Act requires a protection for children witnesses that has to be recognised up front. And I would say, in a sense, if you simply put it into the balancing factors, it's a distinction without a difference, because you're going to be saying to the court, look, all other things being equal, that's the one that's going to carry the day.
It probably is a difference without a real difference. That if it's a balancing exercise, the metaphor is of two scales, and you put some factors in one and some in the other, and some are heavier and some aren't. But if you've got scales, why do you have to have a starting point? I mean, one might ask.
Because we say that you have to build in a level of protection for the child witness, which is not reflected, we would say, in a balancing exercise. We say...
But if you've got a heavy weight, a variably heavy weight, but in most cases, and without any additional evidence than we already have from Pigott, that automatically goes into one side of the scale. Doesn't that produce the same effect?
I think our concern would be that the weight of that argument could become diminished in the competing arguments. I think that's our real concern.
But it isn't given any strength by describing it as a starting point.
Look,
it's still a factor that, I mean, it could be called an end point. That would be the final consideration. But so long as the weight is recognised in the balancing exercise, so long as its invariable presence in the balancing exercise is safeguarded, surely the protection is there.
I think what I'm looking at is an end practical result. And I think if we are saying that what underpins the consideration of whether a child gives evidence or not is the likelihood of that being a damaging experience, I think we would say that that needs to be expressed clearly and upfront. I mean, I don't think I can add to that, but we would be very concerned that if you put it into a balancing exercise, in the sense if you're saying, well, that part of the balancing exercise outweighs Article 6 rights, Article 8 rights of other subject children, and so on and so forth, there is, we believe, a real risk of watering down that protection. It's about maintaining that protection. And I think, in a sense, we intellectually do not have a problem with wording that recognises and preserves that issue. The question is whether, if we put it as part of a balancing exercise, there is a tendency to water it down and a tendency to overlook that that is what drives the consideration of the court. And we say it's a far more honest and it's a far clearer message in terms of the court's expectation of what will happen day by day. And can I just say this, that in our consideration of this, it's a refinement that doesn't appear in here, and I want to put forward to the court for consideration. We do, and it comes out of a comment that your ladyship made yesterday when you said, if you don't ask, you don't get. And actually that's very true, because we don't ask and we don't routinely think about it. And we think that that has got to change. And certainly what we're submitting to the court now is that the question of whether a child who has made an allegation that's material to the consideration of the court should be called to give evidence and cross-examined, that must be considered in every case where that applies. So at the moment you've got a situation where the burden is on, in this case, stepfather, to make the application. He drives it forward. It's for him to make that out. What we would say is if you place it as an obligation on the court at a case management stage in public law proceedings and at the, and I'm afraid they call them all sorts of different things, but there is a first directions hearing for the private law. That it's given all sorts of different phraseologies around the country, but at that first substantive directions hearing, where there is an obligation on the court to say, do we have a material allegation here which may require the child to give evidence? That mandatory consideration is a huge step forward, we submit, in terms of Article 6 rights. That we accept that the burden should not be on the accuser to raise it. It's something that the court, in its inquisitorial role, should be undertaking, we believe, at this time.
I'm not quite sure I follow this. Are you saying that it has recently been introduced, or you're saying that it ought to be introduced?
We say that it ought to be.
This is this something on which you have consulted Kafka's legal?
We've talked
Yes.
broadly about it, and certainly there was no dissenting voice from there, and certainly the guardian who instructs me is entirely on board with that suggestion.
Can I just note it down again?
Yes. We are saying that,
What I noted down, and tell me if I got it wrong,
yes,
is that the question whether the child should be called to give evidence must be considered in every case. The obligation is on the court in care proceedings at the case management conference, yes, and in private law hearings at the first directions hearing, the first proper directions hearing, whatever that is called. Yes, is that correct?
Yes. I think that the introduction to that was that where
And then you said the question was, do we have here a material allegation which may require the child to give evidence?
Yes.
And that should be considered. And rather than putting the burden on the person accused to rock the boat,
absolutely,
stir the pond, whatever it is,
absolutely,
whatever metaphor one wants.
And I'm sorry if that slightly comes on the hoof, but there is no doubt that the Article 6 element of this has troubled us hugely. And we don't feel that the process that we have now, it's almost offensive for a person who is accused of having done something to have to apply for a summons, because that's the way it's been happening. And we find that offensive. That cannot be the right way forward. And so we've been trying to think how you take that element at least partially out of the equation, and it may have to be considered if the child refuses to give evidence. And of course, if you put it into the court's consideration, that will have to be kept under review, undoubtedly be kept under review by the court.
Can I just try one idea? I mean, you were talking a moment ago about starting points. In these proceedings, the starting point, if there is one, is surely that the child's welfare is the paramount consideration, which under the statute is given, I suppose, a slightly greater weight than anybody else's rights. But of course there are several children, or there are a number of children here involved, and one has to feed that into
Yes,
the equation.
The interests of C would not be a paramount consideration, it would be an important consideration, but because of it,
Yes, because there are siblings.
yes, this is not a decision about the upbringing of the child.
This is the point, technically.
Yes.
We're talking about procedural decisions, and although it
Right.
has been held that the welfare of the child is an important consideration in making procedural decisions, it isn't the paramount governing, ruling consideration that it is when you actually make a decision about what's to happen to the child.
But bearing in mind that the procedural decision is really quite important in relation to the making of the proper substantive decision, I can't really detach them very easily.
Well, statute's clear about it, and I think that probably feeds into our feeling that about this being an issue as a starting point rather than in the balance, because you don't have that paramountcy that applies to this decision. We believe that you've got to find some other way of recognising how important this decision is in terms of the child giving evidence. And because we don't have the paramountcy applicable to this, I think that's why we land up in the place of saying to you, we believe there should be a starting point. I think that's at least part of the argument.
Well, would that be a convenient moment,
Oh,
Ms.
my lord, yes, I'm so sorry, yes.
How are you doing, do you think?
I
know we've asked you an awful lot of questions.
I think I've got another 20 minutes.
2 o'clock.
Thank you.